Good afternoon, everybody, and welcome to our seminar this afternoon focusing on data protection in the healthcare sector across Africa. My name is Julie, and I would like to run through a few housekeeping matters, which will hopefully enhance this webinar experience for all of you. As participants, you will automatically be muted, and the chat functionality has been disabled. So should you have any questions during the webinar, please do make use of the Q&A at the bottom of your screen. Your questions will be submitted to me, and I will select a few to discuss with the panel at an appropriate time during the webinar. Please do note that we will not be providing written responses to the questions. Finally, this webinar is being recorded, and a copy of the webinar will be available later today on our website at www.bowmanslaw.com. Now to the topic at hand. Globally, individuals are becoming increasingly concerned about their privacy when it comes to health-related personal information, and this has become increasingly important in the context of the COVID-19 pandemic. There is significant harm that individuals can suffer if organizations do not adequately protect their personal information, in particular their health information. An individual can suffer financial loss or bodily harm, for example, receiving the wrong test result or treatment, and even be discriminated against if their health status is exposed to unauthorized individuals or to the community at large. For example, a few years ago, a US healthcare provider publicly displayed the HIV status of some 12,000 individuals by using envelopes with a window that was too large and exposed the HIV status of the recipient of the letter. It is against this background that we are speaking to you about how we protect and handle personal information, and in particular, health information. First up, we have Daniel from our office in Kenya to discuss the landscape in Kenya. Daniel, over to you.
Thank you, Julie, and good evening, everyone. Thank you for making time to join us for this webinar, and we hope you'll find it interesting and useful. So I'm going to take the next 10 minutes to discuss the legal landscape from a Kenyan perspective. And firstly, I'll go through the relevant laws from a privacy perspective. The first piece of legislation I'll look at is the Constitution of Kenya, which provides for an individual's right to privacy. And pursuant to the provision of the Constitution on the right to privacy, we have the Data Protection Act, which we'll be discussing in great detail this afternoon. Then there's also the Health Act, and also the HIV and AIDS Prevention and Control Act. These two acts provide for the confidentiality of health data. Going to the Data Protection Act, this act has very wide applicability, and it applies to data controllers and data processors who both are resident and those who are outside Kenya and process the personal data of persons located in Kenya. So an entity which is based outside of Kenya may fall within the provisions of the DPA if it processes data of persons who are located within Kenya. Looking at the definition of personal data under the Data Protection Act, personal data is defined to mean information relating to an identified or an identifiable natural person. Looking at sensitive personal data, the Act provides for a very wide definition of sensitive personal data, but for the purposes of this webinar, we'll be looking at those aspects of sensitive personal data that are relevant to the healthcare sector. You'll notice that the definition of sensitive personal data under the Act includes health data, biometric data, genetic data, gender, and gender. So these are the types of sensitive personal data that will ordinarily be processed where a person accesses health services, for instance, visiting a doctor. Going to health data, this term is defined to mean data related to the state of physical or mental health of a data subject, and it includes records regarding the past, present, and future state of health. And it also includes data collected in the course of registration for provision of health services. Lastly, data which associates a data subject to the provision of a specific health service also constitutes health data. Looking at biometric data, these may include information such as blood type and DNA information. One thing to note regarding sensitive personal data is that you cannot rely on consent under Kenyan law to process sensitive personal data. So for sensitive personal data, you'll have to rely on the other grounds for processing such data under the DPA, which I'll get to shortly. Looking at the nature of consent that is required under the Act, the Act is very clear that the consent should be express, unequivocal, free, specific, and informed. So what this essentially requires is that it should be manifestly clear that a data subject has consented to the processing of their data. And therefore, there needs to be an express opt-in mechanism for obtaining consent. So what this means is that the consent of the data subject cannot be implied, but the data subject has to do a positive act, such as ticking a box or whatever other act that can signify consent. It's also worth noting that a data subject has the right to withdraw consent under the Act, but such withdrawal does not affect the processing of data which took place before the withdrawal of the consent. It's also worth noting that the Act places the obligation of proving that consent was granted on the data processor or the data controller, as the case may be. So that burden does not lie with the data subject, but it lies with the data controller or data processor. Considering this, these limitations that may arise from relying on consent, what we usually recommend is for persons processing personal data to, if possible, rely on an additional ground other than consent to take care of situations where consent may be withdrawn and so on and so forth. Having said that, I'll now briefly look at the various grounds for processing personal data under the DPA. And the first one is where the processing of personal data is required for the performance of a contract to which a data subject has entered into. And you'll notice that this ground is the one which is widely relied upon by entities processing personal data. Then processing may take place where it's in compliance with a legal obligation to which a controller is subject, or where such processing is necessary to protect the vital interests of a data subject. It's also possible to, you could also rely on the ground of legitimate interests, which are pursued by the data controller or processor. But the requirement is that this legitimate interest should not be overridden by the rights and freedoms of a data subject. So in this case, it will be necessary to undertake a legitimate interest assessment where you weigh the rights of the data subject against the reason why the data controller or processor wants to process data. Having looked at that, I will now move to the grounds for processing personal data, which are specifically provided for under the DPA. And the DPA requires that where an entity intends to process sensitive personal data, it may do so where the processing relates to data which is manifestly made public by a data subject. Another ground that could be relied upon to process sensitive personal data is where the processing is necessary for the establishment, exercise, or defense of a legal claim, or where the purpose of carrying out, where the processing is necessary for carrying out the obligations or exercising specific rights of the controller or processor. So this second ground is what is widely relied upon when processing sensitive personal data in Kenya. And lastly, another ground that could be relied upon is where the processing is necessary to protect the vital interests of a data subject. So you'll notice that there is some element of overlap between the grounds that will be relied upon in processing sensitive personal data and those that may be relied upon in processing personal data, which is not sensitive. I'll now look at the specific requirements of the DPA with regard to health data. And the DPA has very express requirements that apply to health data. And these are that personal data relating to health may only be processed by or under the responsibility of a healthcare provider or by a person who is under an obligation of professional secrecy under Kenyan law. So an interpretation of this requirement is that where health data is processed by a healthcare practitioner, such as a doctor or a clinical officer in a hospital setting, then such processing will be permitted under the DPA. And I'll now move to processing of data belonging to children. And you'll appreciate that it's very common that a healthcare practitioner may require to process the personal data of a child, where that child goes to a medical facility to access health services. And the Act requires that personal data relating to a child may only be processed where the consent of that child's parent or guardian has been obtained. Or and another requirement is that such processing should be in such a manner that it protects the rights and best interests of the child. So it's very important to ensure that the consent of the parent of that child has been obtained, and that steps are taken, deliberate steps are taken to ensure that the processing that takes place is in the best interest of the child. I'll now look at the requirements for cross-border transfer of data under Kenyan law, considering that it's very common for data to be transferred to jurisdictions outside Kenya or to be stored, for instance, in servers which are located outside Kenya. The key requirement under the DPA relating to cross-border transfer is that the transfer should happen once evidence of adequate safeguards has been provided to the data commissioner. And where the cross-border transfer relates to sensitive personal data, there'll be an additional requirement for the data subject to consent to this cross-border transfer, in addition to providing evidence of adequate safeguard to the data commissioner. So we have, in some instances, assisted clients to get confirmation from the Office of the Data Commissioner. And recently, there's a matter where a client wanted to transfer data to the EU, or the UK rather, and the data commissioner confirmed that actually the UK has adequate safeguards to protect personal data. Having discussed those issues, I'll now briefly go through the other salient points that you may need to have in mind. And the first one is the requirement for registration of data controllers and data processors under the DPA. So it's a requirement for all data controllers and processors to register with the data commissioner, but the thresholds that apply to this mandatory registration have not been set as yet. However, there was recently some draft regulations that were issued by the Office of the Data Commissioner, which are still under considerations and have not been enacted. And these regulations actually, provides for these mandatory thresholds. Another thing to note in respect of Kenya is that it's not a mandatory requirement to designate a data protection officer. However, this may be or will be recommended where there is processing of sensitive personal data. Another thing to note is that in some instances, a data processor or controller may be required to undertake a data impact assessment. And this is required where the processing may result in high risk to the rights and freedoms of a data subject. And where you undertake a data impact assessment and some risks are revealed, the data processor is required to consult the data commissioner before proceeding with the processing. And where a controller or processor have entered into a data processing arrangement, the controller, or rather the processor, is required to only act upon the instructions of the controller. So a processor who acts contrary to the instructions given by a controller is deemed to be the controller in that case, and is therefore required to comply with the provisions of the act that fall on a controller. And one such obligation is the obligation to report any data breaches, which the DPA places that obligation on a data controller. Lastly, on the penalties that are provided for under the DPA, they are fairly high. And the DPA provides that the data commissioner may provide a penalty notice of up to 5 million Kenya shillings, which is equivalent to $50,000 US, or 1% of an undertaking's annual turnover for the previous year, whichever is lower. So those are just some of the issues you may have to have in mind from a Kenyan perspective. I'll pause there for now and hand over to the next speaker. And I'll be available to answer any questions at the end of this session. Thank you for your time.
Thanks, Daniel. Now, Micael from our alliance partner, Aman Assefa in Ethiopia, will tell us how it works in Ethiopia.
Thanks, Julie. Good afternoon, everyone. Fellow panelists, participants, to give you an overview of the legal framework here in Ethiopia regarding data protection, in particular to the healthcare sector. Today allows us to stand in a unique vantage point, one looking at the past and what holds in the near future in Ethiopia. The past or the existing legislation can be described by dispersed and scattered laws embedded within other legislations. Whereas following the past developments in Ethiopia in the past 24 months, we are looking at a new legislation fully dedicated to provide guidance for data protection, processing, and data transfer. I will divide my presentation into 3 parts. One that talks about the existing laws, the other describing the gaps, and finally the initiatives and the upcoming legislation. Currently, there is no comprehensive data protection law in Ethiopia. As I mentioned earlier, they are dispersed and scattered within other laws. Just to give you an overview, I have selected around 5 legislations whereby we can find provisions addressing our topic. The first one is the Ethiopian Constitution, where it describes or gives the right to privacy. Secondly, a 1960 Ethiopian Civil Code provides for certain provisions addressing medical treatment and examination, whereby there's a dedicated provision which describes professional secrecy. Thirdly, we have a criminal code enacted or revised in 2005, whereby breach of professional secrecy is punishable upon complaint with simple imprisonment or fine. We also have another provision within the criminal code that addresses violation of privacy in terms of correspondences. Here again, there is also imprisonment of up to 6 months. A relatively recent legislation is a computer crime proclamation enacted in 2016, where that data processing service and related violations are punishable under this proclamation. This proclamation again deals not directly with healthcare and data processing, but particularly with information related to technology and computer crimes. Lastly, there is a relatively specific legislation. This is a regulation by the Council of Ministers enacted in 2013 to provide for food, medicine, healthcare administration and control. There's again dedicated provision regarding professional confidentiality, whereby a health professional may not disclose verbally or in writing patient information without consent, prominent health risk to the public, court order, or permitted by law. So this is what exists today. And to briefly take a look at the gaps within the system, I would use a phrase which I believe would describe the existing gaps. Today, there's an overall lack of awareness, both from the side of the professionals as well as the data subjects, and lack of clarity regarding data protection, dissemination, retention, processing, digital healthcare, cross-boundary transfer, consent, type of consent, withdrawal of consent, and the like. So I would address that the gap currently is a lack of awareness. As I tried to explain in the beginning, there's a huge initiative, and we've seen a barrage of new legislations coming up in Ethiopia in the course of the past 2 years. Data protection is also one of the laws that we are expecting to be enacted imminently. So I'll take the remaining few minutes to walk you through the overall framework of this law. In the interest of time, and taking note that this is just a draft legislation, I would refrain from going into particulars as there could be changes or amendments in its enactment. This new law is addressed to secure every individual Ethiopian's right to privacy regarding automatic processing of personal data. This proclamation, the draft, which is called Proclamation to Provide for Personal Data Protection, is a big shift where we didn't have a clear-cut legislation addressing the issues that we are all discussing today. This legislation is an enabling legal framework to support personal data protection. I will quickly go into the silent features of this draft law, whereby, as I explained earlier, is a big shift if enacted. It introduces new concepts, including lawful processing of personal data, consent and its conditions, processing sensitive personal data, principles of fairness and transparency, purpose limitation, principles of integrity and confidentiality, and also cross-border data transfer and protections in third-party jurisdictions. The new law has dedicated a significant portion to address the rights of data subjects, including their right to be informed and right to access. It has also clearly outlined the concept of consent, that it should be given freely in an informed and unambiguous manner, and the wishes of the data subject, either by a statement or clear affirmation action. The new law also governs and sets rules regarding data collectors and data processors. Under the new law, healthcare is categorized as a sensitive personal data, whereby physical and mental health related data and records are addressed in this particular category. It defines physical or mental health as information on the provision of healthcare services to the individual, which reveals his or her health status. Above all, and addressing these critical points, this new legislation also establishes a dedicated government institution, which envisages to monitor the use of sensitive personal data, investigations, registrations, enacting subsidiary laws, and also penalizing those violators. I hope this presentation was done after the enactment of the law so that we could have gone into particular details, but hopefully we'll have another session to address these things in the near future. Over to you, Julie.
Thanks very much, Micael. Jumoke from UUBO in Nigeria will now tell us about the legal landscape in Nigeria. Over to you, Jumoke. Thanks.
Thanks, Julie. Good afternoon, everyone, and it's nice to be here. I think you will find in the course of this webinar a lot of overlaps between the jurisdictions, but in Nigeria, as with the other jurisdictions we've heard, the basis for data protection, or privacy, I should say, is contained in our constitution, which guarantees and protects the privacy of citizens, their homes, their correspondence, telephone conversations, and telegraphic communications. So what we have in terms of data protection specifically is the NDPR, the Nigeria Data Protection Regulations, that were issued in 2019 by the National Information Technology Development Agency, who I will call NITDA going forward. These regulations are not substantive legislation. At the moment in Nigeria, there is a data protection bill before the National Assembly, and that bill, when passed, there are a lot of similarities with the NDPR, but there are some nuances that will bring in some differences, such as the establishment of a data protection commission. So what does the NDPR do and who does it apply to? For the purposes of Nigerian data protection, the NDPR regulates anyone who processes or controls the personal data of Nigerian citizens, whether they be resident in Nigeria or not, or Nigerian residents, whether they be Nigerian citizens or not. The regulations apply to natural persons, so they do not regulate companies. Under the NDPR, it provides that personal data must be secured and processed by lawful means. So what is personal data? Personal data is, as we have heard from, I think, both Ethiopia and Kenya, it's defined as any information relating to an identified or identifiable person. And it breaks it down further to say this can be ascertained using either regular identifiers such as a name or an email address, a phone number, a photo, to unique identifiers such as your IMEI numbers of your telephones. And for that, the NDPR sets out 5 categories of processing bases that will be determined to be lawful. Before we go into that, because it may not be fully relevant to this conversation, so I will not really itemize them right now, the NDPR now goes forward to determine what it calls sensitive personal data. And now in sensitive personal data, the regulations say this relates to data concerning a person's religion, other beliefs, sexual orientation, health, race, ethnicity, political views, trade union membership, etc. And the NDPR, through its implementation framework that was issued in November 2020, says for the purposes of processing sensitive personal data, this can only be done with explicit consent. So it rules out every other basis of processing. So what this means is where a healthcare organization, as we know, will be collecting information that is deemed to be sensitive personal data for the purposes of the NDPR of anyone who is a data subject under the NDPR, then they must ensure that they have obtained the explicit consent of that data subject. And that consent must be given freely and without coercion. Basically, what the NDPR is trying to do is set the tone following the GDPR of Europe, so that Nigeria has in place policies that will safeguard the data of its citizens and residents, especially in the age we live in, where data has become the new gold or oil, depending on where you're located. And so what it's introduced now is that we have a situation where everyone who is either a data controller or a data processor is required to have in place data protection policies. And these data protection policies are really to regulate your internal officers or workers who will be collecting the data of data subjects to educate them on the obligations of the organization under the NDPR. The NDPR also requires that healthcare organizations, as with any other controller or processor, must have a data privacy policy, and that must be located everywhere that it seeks to use as an avenue for collecting personal data of data subjects. They are also required in the data privacy policy to indicate what sort of data they will be collecting, the purposes for which the data will be used, how long they will keep the data, and the rights, the other rights of the data subject, which includes the right to ask that their data be deleted, and that can only apply to data post the application for deletion. It also requires that the data subject have the right to amend their information, the right to move their information and relocate it to another healthcare provider, and safeguards all of those rights. And the data controller and processor or processor is required to respond immediately to this request unless it has legal reasons for not doing so. I will not focus too much on what the NDPR says, because I think you will find that by the end of this webinar, everybody has said the same thing. But I want to talk about the unique differences that we have in the regulations in Nigeria. And one of them we find in data transfer. So transferring data to third-party countries follows a unique process in Nigeria. You are required to obtain the approval or transfer the data under the supervision of the Attorney General of the Federation of Nigeria. The application is made to the NITDA, the regulator, and submitted to the Attorney General. The Attorney General gives his response by issuing what is called an adequacy decision. And that adequacy decision speaks to the status of data protection policies and regulations in the country that the data is being transferred to. There is currently a white list of 44 countries who the NITDA have affirmed have in place adequate data protection rules and regulations. However, that notwithstanding, you are still required to apply for an adequacy decision. The fact that it's a country on the whitelist merely simplifies the process. So in addition to that, where a data processor or controller is transferring their information to a related entity or a parent company or a subsidiary, then you are allowed to do so using binding corporate rules. And what this means is if you have a binding corporate rules in place, you can that will be the document you submit with your application for an adequacy decision, and that is usually sufficient without more. Your binding corporate rules can also be part of your data protection audit report, and I'll speak about that in a minute. And also you can include it in your data privacy policy that's displayed for all your data subjects to see. So basically that is unique in Nigeria. And so I spoke about the audit. What the NITDA also does, which is unique to Nigeria, that at least to the best of my knowledge, is they've introduced helpers. And these helpers are called data protection compliance organizations. They're licensed by the NITDA, our firm is one of them. And what we do as a DPCO is to conduct an audit of data processors or data controllers. And where the data controller or processor processes the data of more than 2,000 data subjects, then we're annually required to file that report with the regulator. It's filed not later than the 15th of March every year. The Data Protection Compliance Organization is also required to train the senior management members of the data processor or controller on the rules and regulations around data protection in Nigeria, basically to keep them up to speed and allow them to understand the obligations they have under the NDPR. As Micael said, that's one of the key issues in Nigeria, is the fact that a lot of people are not aware of the NDPR. And you find that at the last minute when they hear about it, they start to rush to comply. The data protection rules in Nigeria also require that data controllers and data processors have what we call a data protection officer. That will be the person in the organization who assists with all issues that have to do with data protection, and to also respond to any data access requests from data subjects. I know I don't have that much time, but there's just so much to say. I can see Julie looking at me, but Julie, I just want to add that, you know, part of what we're seeking to do in Nigeria is to ensure that Nigeria is not left behind in this race for data protection, and to ensure that what we do safeguards the rights of our data subjects. One of the things that we talk about is consent, right? And when we look at consent, the NDPR has actually introduced, where it comes to children, a new requirement of what the minority age is. For the purposes of the NDPR, the minority age is actually 13. Under the Constitution, it is 18. So that means that any data for anybody under 13 must be obtained with the consent of their guardian or their parent. So basically what we have is a situation where healthcare organizations are facing stricter rules of compliance. As I said, there are other regulations that speak specifically to the healthcare industry, but you will find when you review those that they speak to disclosure as opposed to collection and processing. So the NDPR speaks to the processing and the control and the maintenance and how you handle that information and your obligations thereunder. There are liabilities for non-compliance, and they're similar to the liabilities that we heard, I believe, in Kenya, which is up to 2% of annual turnover of the defaulting company. I will stop there and hopefully have more time to share some more insights on the NDPR in Nigeria. Thanks, Julie. Back to you.
Thanks. Thank you very much, Jumoke. Thanks for your questions. I think we'll answer them at the end. I'm going to introduce Joshua now from our office in Zambia. Joshua?
Thanks, Julia. Good afternoon, everyone. I'll now present on the landscape in Zambia. Like other countries, I think Zambia also has attempted to ensure that the data for its individual citizen is protected by enacting the Data Protection Act, which was enacted in April this year. The Data Protection Act applies to all organizations who collect or process individual data for citizens or individuals in Zambia. I think like Nigeria and Kenya also, the Data Protection Act also differentiates between personal data and sensitive personal data. Sensitive personal data includes information which may be used to suppress an individual's fundamental freedoms or rights. And this includes but not limited to information such as biometric information or genetic information, and in particular any information relating to a person's physical or mental health. There's no per se specific definition of health data, but from the definition of sensitive personal data, we can say there that health data will fall under sensitive personal data. And the provisions under the Data Protection Act in relation to sensitive personal data will apply to any health data. In addition to the Data Protection Act, we also have the Health Professions Act. This is a law which regulates health professions as well as health facilities in Zambia. The Health Professions Act also establishes the Health Professions Council of Zambia as a regulator of health professions and health facilities in Zambia. The Health Professions Council of Zambia, in an attempt to regulate the sector, issues codes, standards, and guidelines. And most of these are in relation to privacy issues, the rights and duties of patients, as well as the obligation to ensure that this confidentiality between for the information which is provided by the patient. However, the coming in of the Data Protection Act is more like a game changer for Zambia. Because unlike the Health Professions Act or the standard codes or guidelines issued by the Health Professions Council of Zambia, the Data Protection Act has expanded the data protection obligations for any person who collects or processes information or health data. In addition to that, the Data Protection Act also has imposed, I think, hefty fines for breaching the provisions of the Data Protection Act. And these fines are as high as 30 million kwacha, which is an equivalent of about $1 million US dollars. Considering that the Data Protection Act deals with the collection and processing of data, it is very important for health professions, health facilities, or any person dealing with health data to ensure that whenever they are collecting or processing health data, they should understand the legal basis of collecting or processing that health data. And the Data Protection Act provides guidance in that regard. The Data Protection Act in this regard requires that you may collect or process data either using consent of a data subject, I think, which is key, and should be your primary basis of collecting information, getting consent of the data subject, or relying on the provisions of the Data Protection Act. The Data Protection Act, I think, anticipates that when you're dealing with health data, it may not be possible to obtain consent from the individual subject. And therefore, when it comes to collection of sensitive personal data, which includes health data, you are permitted to collect that data without the consent of a data subject in an event of an emergency, and that data is required to assist or for provision of medical services. In addition, once that data is collected, when it comes to processing also, you are not permitted to process any sensitive data except where that processing is necessary for purposes of medical diagnosis, for purposes of treating a patient, for purposes of either managing a medical system or service. So there, in the event that you are a health profession, health facility, you are unable to obtain the express consent of a data subject or a person, you can rely on the legal basis of obtaining that or collecting and processing that information, provided you can demonstrate that that information was necessary for either a medical diagnosis, for purpose of treating that patient, or for purpose of managing a medical system. Other than the obligation to ensure that you've got the correct legal basis of collecting and processing the information, as a person with or collecting or processing health data, you fall under the category of a data processor or a data controller under the Data Protection Act. And as such, you'll be subject to certain obligations which you need to comply with. And some of these obligations, I think they've been discussed by Daniel and I think briefly by Jumoke. And mainly you're required to be registered with the Data Protection Commission. You're required to ensure that you've got a data protection officer who will be in charge of all data protection issues and to ensuring that your organization complies with obligations under the Data Protection Act. You're also required to ensure that when processing information, you have regard to the rights of the people or the individuals who've provided information to you. And some of these rights include the right for an individual to correct or to rectify whatever information they've provided, the right to withdraw information, the right to access that information, the right to be informed of the use and the purpose of that information. And also you've got an obligation to ensure that you've got adequate securities to ensure that there is no data breach in relation to the information provided. Another interesting aspect of one of the features I think I wish to mention has to do with research. So if you are an organization who deals with research and research involves health data or any information in relation to a person's physical or mental health, you'll be required to obtain consent. But in addition to that, you need to obtain authorization from the Data Protection Commission before you can undertake any research which has to do with health data. And in undertaking that research, you also have to ensure that that data is anonymized. Furthermore, in the event your research or your health facility is part of a network of other international organizations, then we need to transfer the data you collect in Zambia. Then there's an express provision under the Data Protection Act that all sensitive personal data must be processed and stored in Zambia or using a data center in Zambia. But should there be need that that data should be transferred, you can transfer that data by the data subject or the person who's provided that information to provide an express consent that the data may be transferred out of the country. Alternatively, you'll be permitted to transfer that data in the cases of, in an event of an emergency, and that data is being transferred to another person who's in the business or who's about to provide an emergency medical service in relation to the data subject. Mainly those are some of the key provisions of the Data Protection Act in relation to Zambia. And to conclude, our Data Protection Act was just enacted in April this year, and the Data Protection Act has got no transition or grace period. And therefore, all the provisions took effect as of 1st April this year. However, in terms of enforcement, it appears that most of the provisions for them to be enforceable, they largely depend on the office of the Data Protection Commission, and that office is yet to be set up. In addition, there are certain regulations and guidelines supposed to be issued by the Minister and the Data Protection Commission, and these are yet to be issued. So I think this period between the effective date of the Data Protection Act and when the office will be set up, that's a time for certain organizations to ensure that they've got appropriate internal governance mechanism to ensure that should the office of a data protection be set up and operational, they are up to date and they're able to comply with the obligation of the Data Protection Act. And certainly this is something we are currently assisting with clients in terms of checking their policies to ensure that they're compliant with the Data Protection Act. With those few remarks, I hand over to you, Julia, Over to you, Julia.
Thank you, Joshua. Now, second last, we have Brian from our office in Uganda. Brian? Brian, you're on mute.
Oops, sorry. Good afternoon, and thanks, Julie. I think it has its advantages to go second last because most of the ground has been covered, and my job is going to be a very easy one. But just like Kenya, the Constitution of Uganda ensures the right to privacy, and then the Data Protection Act implements that constitutional aspiration. The Data Protection Act is a 2019 law, and it applies to anybody who collects, processes, and stores data in Uganda, or anybody out of Uganda who collects, processes, and stores data relating to Ugandan citizens. So unlike most of the data legislations, the Uganda Data Protection Act is consent-centric, if I can call it that, which basically means that you can do anything with somebody's personal data as long as the data subject consents. So consent is a very key thing, and perhaps someone may ask what is defined as consent. And again, just like Kenya, it's any free indication, fully informed indication of agreement or affirmative action agreeing to the collection and processing of personal data. So, so the Uganda Act also distinguishes between what I would call ordinary data and then special data. Other people have called it sensitive data, but this side it's called special personal data. And it's defined to include medical records and health status. So apart from this distinction and how it can be collected and processed, the provision generally applied to all forms of data, and I'll take you to the exceptions. So the default position for special personal data is that it shouldn't be collected at all. But of course, there are three exceptions. The first being if the data subject consents. Then the second being that it can be collected without the consent of the data subject by the body responsible for statistics in Uganda. So that's the National Bureau of Statistics. If they're going to run their statistics, they can collect, they can properly collect this data without consent. And then the third exception is that the collection and processing of personal data should be for an obligation imposed by law on an employer. And I think that's very important, and I'll tell you why. So these are the three exceptions. And now this raises an interesting point during this pandemic. As I don't know in other countries, but in Uganda, anybody who goes to a public place is required to have their temperature taken, for instance, as one of the measures to prevent the spread of COVID. Now, when you look at these exceptions, that one doesn't fall under one of the exceptions of taking somebody's special personal data without their consent. But well, so far nobody has raised an issue, and so far so good. But it raises an interesting legal argument whether that is permissible. So and to just give you a broader view in relation to vis-a-vis special data vis-a-vis ordinary data. So and just to show you how different it is. So for the other data, you can collect it where it's for the performance of a public duty. You can also collect it without consent if it's for national security. You can collect it without consent if it's for prevention, detection, protection, or punishment of an offense or breach of law. And you can also collect it for a legitimate interest. So those are quite broad, but you can do that for special personal data. The other general principles really apply to all forms of data without distinction. And one of them is transfer or storage of data out of Uganda. This applies for both personal, rather special data and ordinary data. So this data can be transferred out of Uganda with the consent of the data subject, or where the data is transferred to a country that has adequate data protection measures equivalent to Uganda. Now, those countries that meet this criteria are supposed to be gazetted, published by the regulator, the DPO, the Data Protection Office. But as we speak, they haven't done that. So So we normally advise clients that to be on the safe side, just get the consent. I mean, there are obvious countries that I think should be on that list, probably countries that are covered by the EU and probably the United States. But to be on the safer side, we recommend that just get the consent of the data subject. The other points have been mentioned, registration for all of data collectors, processors, and controllers is mandatory. For where the collection of data is likely to impact rights of a big number of citizens, then you're supposed to do a data impact assessment. So in a way, it is not very dissimilar to Kenya. So briefly, that's the view from Uganda, and happy to hand over to Julie.
Thank you very much, Brian. Now, last but not least, Nadine from our South African office. Nadine.
Thank you very much, Jules, and good afternoon to our fellow participants and attendees. I appreciate that we are running out of time, so I will try and be as quick as possible. But thank you for those who can stay on a bit longer. As many of you may be aware, data protection has been a hot topic in South Africa recently, and this is because our first comprehensive piece of data protection legislation came into force last year. Now, organizations were granted a 12-month grace period in which to ensure compliance with the Act, and that grace period came to an end at the beginning of this month. So going forward, the South African Information Regulator can now take steps to actually enforce the provisions of POPIA. Now, briefly, prior to POPIA, your right to privacy within the healthcare sector was regulated in terms of course, our constitution in South Africa, but also various other pieces of legislation, such as your National Healthcare Act and your ethical guidelines that have been published by your Health Professions Council. And these laws imposed a number of obligations on entities, as you may be aware, in relation to the manner in which you deal with health information, particularly in a way that secures the integrity of the information and protects its confidentiality. But in terms of POPIA, it is going to have far-reaching implications for entities within your healthcare sector. That includes your pharmaceutical companies, your healthcare professionals, medical aid schemes, insurance companies, and the like. So for purposes of today's webinar, I'm really just going to focus on the provisions of POPIA and three key areas in which we have received a number of instructions and queries from clients in the healthcare sector. And that is firstly, the key steps entities will need to take to ensure compliance with POPIA. Secondly, the grounds upon which health information can be processed. And lastly, the circumstances under which health information can be processed or transferred, at least cross borders. So personal information for purposes of POPIA is information that identifies a living natural person. And this includes your health information, well-being, disability, and medical history. Now, unlike the other jurisdictions that we've heard from today, POPIA actually goes further, and it also relates to the personal information of juristic persons. So that could be their registration details, their contact numbers of an insurance company or medical aid scheme. You as the entity yourself have personal information. So when someone else is processing that information, they need to do so in accordance with POPIA. Now, unlike Nigeria, where the real focus is on when you're processing personal information of Nigerian citizens or residents, when it comes to POPIA, it actually focuses on where the processing is taking place, and it focuses on processing in South Africa. So if you're an entity that processes information entered into a record in South Africa, or you're situated outside of South Africa, but use means in South Africa to process the information, you will need to comply with POPIA. Now, what does this mean? The backbone to POPIA is mainly your compliance with the 8 conditions for all processing. Now, the 8 conditions we unfortunately don't have time to go into today, but really relate to securing the information, notifying data subjects of certain information before you can process it, reporting data breaches, etc. But you will need to ensure compliance with those 8 conditions. In addition to that, the key steps that we mentioned that are must-haves under POPIA. The first, unlike Kenya, is that you do have an obligation to register an information officer with the information regulator. That is a must-do. Secondly, you need to implement and develop a compliance framework and conduct an impact assessment to show that your entity is complying with POPIA. So again, unlike Nigeria, where it has an obligation to have a policy in place, we get a lot of queries about we need a POPIA policy. That is not a legal obligation. You don't actually need a policy, but you do need a compliance framework and to undertake an impact assessment. Another thing you do need to have in place is your manual. You need to have a manual in compliance with both POPIA and your Promotion of Access to Information Act. And lastly, a legal obligation on your information officers is to conduct awareness sessions. We've discussed today from various of our jurisdictions how important awareness is on the topic, and this is one of the requirements under POPIA. So now moving briefly onto the processing specifically of health information. Now, similar to your other jurisdictions like Kenya and Nigeria, POPIA identifies a category of special personal information, and that includes information relating to an individual's health or sex life. Now, there is a general prohibition on the processing of special personal information, and this is subject to certain limited exceptions. The first is consent. The definition of consent for POPIA is identical to Kenya. It's got to be specific, express, informed consent. Alternatively, if you don't have the data subject's consent, it could be that it's been made deliberately public. Someone could have published information about their depression on an open social media platform. You can process that information because it's been made public, or where you need to comply with an obligation imposed by law. So this could be for purposes of your COVID-19 regulations. You need to process the health information to comply. There are also instances where you may want to request authorization from the information regulator where there's no other ground on which you can process, and the information regulator can authorize the processing of health information. She has recently published guidelines on this issue of authorization. Should you want to have a look, those are published on her website. But in addition to these general grounds that apply to all types of special personal information, religious, race, etc., there are other specific grounds that apply to health information under POPIA, where they recognize certain companies, specifically a lot of our attendees on this call, may need to process information. And that includes where the processing needs to be done by medical professionals or healthcare institutions for the proper care or treatment of a data subject. Where the processing is conducted by the insurance companies, your medical aid schemes and administrators in order to assess risk for an insurance policy, to comply with an agreement that you may have between a medical aid scheme or insurance company and the data subject, or to actually enforce rights under that. So that, I think, is going to be a ground that we are going to see a lot of entities take up and use, specifically those entities that fall within the insurance and medical aid scheme sectors. And another specific ground is where you can process information if you're an administrative body, a pension fund, or an employer, if it's necessary to comply with labor laws, a collective agreement, or to actually reintegrate workers into the workplace. And this could be due to capacity or ill health reasons. So when they're entitled to a benefit, you can process that information. So those are very special grounds on which you can process information. The information regulators can also develop rules in relation to specifically health and sex life, the processing of that information. No rules have yet been developed, but we do understand that they are underway and will be published shortly. So just moving on to the last topic of cross-border transfers. Now, we receive a lot of requests in the healthcare sector industry when you're conducting clinical trials or donation agreements where you have to transfer information across borders to various other foreign jurisdictions. Now, POPIA does regulate the cross-border transfers of personal information, and there's actually a general prohibition on the transfer, subject to certain exceptions. Now, the first exception, which we call a sort of safe harbor type of exemption, that is where you're sending it to a third party in a foreign country that's subject to a law, binding corporate rules, or binding agreement that provides for an adequate level of protection. Another ground is where the data subject consents to the transfer, or where you need to do it for performance of a contract. Now, going back to the sort of safe harbor type of exemption, one of the questions we received is, well, how do we know what laws are adequate? Unlike Nigeria, our information regulator is not going to be rubber stamping the laws. They're not going to be assessing what is adequate. They've indicated recently, and actually in a webinar this week, that we as the entities will need to assess what is adequate. We'll need to assess the laws and take a decision on whether we think that adequately uphold the provisions of POPIA. If we don't, we need to implement your binding agreements or your binding corporate rules. But again, the information regulator will probably only assess it when there is an issue, and they've indicated that they'll assess it on a case-by-case basis. So unfortunately, we don't have any current guidance, we don't have red lists and white lists, and we're going to have to make that indication ourselves. And then lastly, one of the issues in relation specifically to the transfer of health information across borders is this requirement to obtain prior authorization from the information regulator. Now, if you intend to transfer special personal information, which includes health information or information relating to children cross borders to a foreign country that does not provide an adequate level of protection, you will need to get the prior authorization from the information regulator. But it's important to understand that it does not provide an adequate level of protection, because we can create an adequate level of protection by entering into a binding transfer agreement or binding corporate rules. So before you go and obtain authorization, consider doing a binding transfer agreement or rules. But if that is not possible, you need to apply for prior authorization. Applications need to be made before February next year, and the information regulator is busy determining them and will give you a result in terms of whether the processing can take place. Thanks, Jules.
Thank you, Nadine, and thank you everyone for your overviews today. I think that they have been really helpful, if anything, to make people aware of what they need to know. We have had a number of questions, most of which have been answered in the chat. I don't know whether this chat remains available for everyone to read in their own time. There is one additional question which has been asked of all of the participants, and I'm sure we can answer that question. Maybe not now, but maybe afterwards, given that we run out of time on this call. But I think it remains to be said. Thank you everybody for coming and joining us today. Thanks especially to the participants. And if you have any other questions, please do let us know. And yeah, have a wonderful day, and thank you very much. Bye, everybody. Thank you.